Good morning and welcome to another Hometown Credit Union Lunch and Learn. Today we are excited to have John Buhta of the Southern Minnesota Regional Legal Services join us to talk about your rights as a consumer when dealing with debt collectors. John had a lot of great information to share. I met with him earlier this week to record our session, and I'm going to share that with you now. If you have any questions, please don't hesitate to contact us, and we'll be happy to get back to you with information on whatever your inquiries are. And if you have any ideas for future topics for Lunch and Learns, we'd love to hear about them. We're always looking for new content. Okay, so let's take it away to John.
Good morning and welcome to another Hometown Credit Union Lunch and Learn. Today I am really excited because we've got a fantastic guest joining us. We have John Buhta, who is an attorney at law with Southern Minnesota Regional Legal Services. And welcome, John.
Thank you, Kurt. Thanks for having me. So I think I'll just jump right into this here. Good morning, everybody. Like Kurt said, my name is John Buhta. I'm an staff attorney at Southern Minnesota Regional Legal Services. Hopefully some of you already know about our organization. If you want to learn more, you can go to the website, www.S.M.R.L.S.org. But basically, we provide free legal assistance to not afford an attorney on a variety of legal matters, including housing cases, family law, and soon to also include some consumer law issues, which this presentation will cover a small piece of consumer law, which is called the Fair Debt Collection Practices Act. And I'm going to try to go over some of the basics here and give you some ideas of what you can do if you think you are having problems with debt collection. So we'll start with the purpose of the Fair Debt Collection Practices Act. It's the main federal law that governs debt collection practices. It prohibits debt collection companies from unfair or deceptive practices to collect debt from them. And one of the most powerful things that you can do using the Fair Debt Collection Practices Act is you can contact the debt collector and have them stop contacting you. A lot of times they'll be calling you, 5 or 6 times a day, all times during the day, and people get tired of it. So the first thing that you can do is contact that debt collector in writing, usually a good idea. And if you have an attorney, you can tell them that you have an attorney, or you can tell them that you don't want them to contact you anymore, and they should stop contacting you. So that's really important.
John, tell us why in writing is the best method for communication like this.
Sure. So that is a couple of reasons. One, so that it's clear that there's a record of exactly what you owe that debt collector that you wanted. So sometimes you might not, maybe you're not as concerned about them contacting you, but you're more concerned about what the debt is, or you don't understand why they're saying that you owe money or who they're talking to, because it might be a company that you don't recognize. Maybe you had a credit card with Visa, and now you're being contacted by Midwest Financial or something about a debt, and you don't understand where that came from. You can write a letter asking them to confirm or verify what the debt is, and putting it in writing will make it clear exactly what information you're asking for. It's also important if it comes to a point where the debt collector is not following the Fair Debt Collection Practices Act and they're violating some of the other protections that we'll be talking about later in this presentation. It's good to have that letter in writing so you have proof that you requested information or you asked them to stop contacting you. And if they continue to contact you, for example, after that letter, that would give you a cause of action, what we call the right to sue that debt collector for damages and for violating those protections under the Fair Debt Collection Practices Act. So it's always good to do it in writing and then keep a copy of the letter for yourself, so that if you need it for proof or you want to go to a lawyer and you can say, this is the letter that I sent to the debt collector, and you have copies of that.
And does the consumer need to mail that a certain way, like registered mail or certified or anything, or is that not quite as important?
You know, it depends. Some people, you know, they might not have the ability to do a letter certified mail. As long as you mail it to the debt collector and you have a copy of it and you are able to say, I put this in the mail, that's going to be a presumption, you know, as a legal term that was sent correctly. If you want to be extra careful, then doing it as a certified letter or doing it with some kind of confirmation or tracking number couldn't hurt, but it's not necessary. So we'll move on to some of the important terms in the Fair Debt Collection Practices Act. A debt collector is a very specific term in this act, and it doesn't cover everybody that might be trying to collect debt. It has to meet this definition, which I put on the slide, and I won't read it to you, but I do have an example. So let's say that I owe money to Kurt, and you know, I haven't paid him for a while. Sorry, Kurt. And he decides, instead of trying to collect the money from me because he's a businessman working and do a lot of lunch and learns, he's going to hire Mary to get the money from me. So Mary is going to contact me and try to get me to pay. Either Mary, if I pay money to Mary, then Mary might take a percentage of that and then give the rest to Kurt. Or Mary might give me a little wake-up call and remind me that I need to pay Kurt. But either way, Mary would, in this example, would be the debt collector. So an exception to debt collector, and this is why I use that example, is the person that I actually owe the money to originally is not a debt collector. So in that example, Kurt, because I owe you money, you're considered to be the original creditor. And that means that these protections that we're talking about today do not apply to Kurt. So if I can't have Kurt stop contacting me, like we were saying before, if I wrote a letter saying, please stop contacting me, and Kurt continued to contact me, he would not be violating that, the Fair Debt Collection Practices Act, because he's the original creditor. So Mary, yeah,
Go ahead.
yep, and Mary, on the other hand, as the debt collector, would still have to follow those. And there's a few other exceptions to this. If someone is an officer of the government, they're not considered to be a debt collector. A few other types of categories, but attorneys, and this is important for our office. Sometimes some of the attorneys we work with that are working on behalf of landlords, for example, their main part of their practice is trying to sue tenants for money on behalf of the landlords. They would be considered a debt collector. So, sorry, Kurt, did you have a question about that?
Yeah, so an example, I know a lot of people deal with medical debt. And so the initial point of contact is probably going to be somebody working for that medical facility that's reaching out to you and saying, hey, you've got overdue balance, how much you owe, things like that. So they would be considered the original creditor. But after a period of time, they might say, okay, this consumer is not paying, we're going to turn this over to a debt collector. And at that point, the debt is being collected on behalf of the collector.
That's right. Then the debt collector would start to become subject to these rules under the Fair Debt Collection Practices Act. That's right. And some, it gets a little bit complicated, but sometimes the debt collectors, they will purchase the debt from the hospital or the medical provider and then collect it. They say they're collecting it on their own behalf, but there are some interpretations of the Fair apply to that debt collector, because that's their main business, is buying other debt and then collecting on it. That they can't get around that, those protections. And actually, my next slide gives some examples of the types of debt that are covered, and medical debt you'll see is on there. Some of the other ones, credit cards, mortgages, but really anything that's used for a personal or family or household purpose would be considered debt, covered under that Fair Debt Collection Practices Act. The only, one of the big categories of that's not covered would be a business debt. If someone had their own business and had a line of credit for that, that this would not apply. So one of the other main protections that the Fair Debt Collection Practices Act provides is that the debt collectors cannot contact you at what's called an unusual time or place, or a time or place that they know is inconvenient. So if they've called before and you told them to not call it at this time or a certain day, and they continue to do that, that would be a violation of the Fair Debt Collection Practices Act. And if you want to have some kind of record of that, even if you just keep a journal next to the phone when a debt collector calls, write down the time, date, and what you told them. If it was, don't call me back around at this time, or don't call me at all, that goes back to the earlier slide. Ideally, you do that in writing, but even if you do it over the phone, if you have a record of it, you can use that in the future as they continue to violate. There's also a clear requirement that they cannot contact you before 8 p.m. or after 9 p.m. So if that's happening, again, you want to make note of that in a journal of some kind, so that you can go to a lawyer later if you want to decide you want to take that debt collector to court for violating your rights. There's also a requirement that they cannot contact you at work if they know that you're not allowed to get those types of calls at work. So you have to at least tell them that if it happens once, tell them I can't talk at work, they should never do it again. And if they do that, that's time is another violation. And like I said before, if you tell them that you're not to not contact you anymore, or that you're basically just tell them I'm not going to pay this, you're wasting your time, or that you have an attorney, those are all 3 reasons why they should stop talking or stop calling. Now, there are some other general categories of conduct that is prohibited by the Fair Debt Collection Practices Act. Harassment or abuse, false or misleading representations, and unfair practices. And the law, of course, goes into a little more detail of each of those categories by giving some examples, but these are not examples that have to be, it doesn't have to be one of these. It's not an inclusive list. There are other things that could be considered harassment or abuse. Just because they're not on this list doesn't mean the debt collector can do that. But for example, a threat to use violence or other criminal means to harm a person or threaten them to collect the debt, that would be an obvious violation. Using obscene or profane language would be considered a violation, and you could make a note of that if that's happening. Sometimes debt collectors try to get creative and they want to publish a list of people in the paper that owe money, or on their website. These are all the people that are refusing to pay us. That would be a violation of the Fair Debt Collection Practices Act. Yes, Kurt?
So in the instance of property taxes, people owe property taxes to the county. Those lists get published in the paper, but they're able to do that because that's the creditor that's listing that, not the collector. Is that correct?
Yep, that would be one reason. It does, and it also, as I had indicated, what the definition of a debt collector wouldn't include any kind of government entity. So that would be another exception. That's
Sure.
right.
Got it.
But they would be the original creditor in that case as well. And there are times where the government will hire an outside debt collector. Sometimes it's student loans that you might owe to a servicer, and they'll they aren't paid after a certain amount of time, they might send those to a debt collector. Now that would still apply to that debt collector, just because the original debt was owed to a government agency. If it's going through that debt collection process, they still need to comply with the law. But the sort of things like that, where the property taxes, if it's still the county that's get paid, then that absolutely right, they are the original creditor, so they can do things that might otherwise be prohibited by the Fair Debt Collection Practices Act. Some other examples of things that are prohibited for a debt collector: they can't put that in an advertisement, kind of a similar, posting it online saying, if I'm going to sell this debt to someone, but that's just another way of embarrassing someone for saying that you owe money. Another example, causing the phone to ring. Basically, just calling someone over and over again to harass them would not be, would be a violation. That's not allowed. At work, calling somebody and not saying who you are or where you're calling from, that would be considered harassment or abuse. There's also a category of false or misleading representation, and this, I think, happens probably more frequently than the abuse and harassment. Is they call and they're saying things, that aren't necessarily true or are misleading in order to try to get people to pay the debt. And they again give many examples in the statute, but that they can't possibly cover everything that's prohibited. But some examples they give are, falsely representing that the debt collector has some kind of, government credentials or a law enforcement type role. They, to kind of scare people, that would be misleading in most instances. This one is very common, falsely representing the amount of the debt. If there's a dispute over any aspect of the thing that I think of as the most obvious example would be somebody may have owed money to a landlord, a prior landlord, after you moved out. The landlord says that you owe them rent, or they say that there was damages to the apartment, and they're sending a bill for a large amount of money. A lot of times that's disputed by the tenant who moved out. They dispute that they did any damages or that those damages were there when they moved in. They dispute the amount of rent that the landlord says is owed. But the debt collector comes down the road after the landlord hires a debt collector and is representing that this amount, whatever the landlord told them, was the right amount, and the tenant disputes that. That could be just there alone a violation of the Fair Debt Collection Practices Act, because the debt collector is saying that you owe something that you might not actually owe, including maybe attorney's fees or fees for debt collecting the debt which weren't in the original lease. Those would be charges that you shouldn't have to pay and legally wouldn't owe. And if they're representing that you do owe that, again, that's a violation of Fair Debt Collection Practices Act. They also might occasionally will imply or represent that they can put you in jail if you don't pay, or that they're going to take away your car or some other personal property. In some cases, they really could take your car if it's a car loan, but in most cases, that's not going to happen. So to represent that, and just as a way of intimidating people into paying, is a violation of the act. If they ultimately do take someone to court, a debt collector could sue somebody for the debt or the original creditor on behalf of the debt collector could sue if they own the debt, or on behalf of the original creditor, an attorney is suing. That could ultimately result in some of those things, although not imprisonment or arrest, but the garnishment of wages, for example, but that has to go through a whole process before we get to that point.
John, with the garnishment of wages, would you be aware that that's something that they're working on?
Right, you will know, should at least find out long before that happens, because the process that requires first for them to take you to court, prove that you owe whatever the debt is, and that would be one opportunity. To go back to my landlord example, if the landlord or the debt collector that has the debt from the landlord does take you to court, you can go into court and say, no, I didn't owe that money. You know, those other charges that they're saying I owe, there was nothing in the lease that required you to pay that. And then a judge will decide whether you owe any money or not. And it turns out if you did owe some money to that landlord, then the judge will enter a judgment against you for that amount. But the landlord or their attorney or the debt collector still has to go through a process to then collect on that judgment. And one of the processes that they can follow is to find out where you work or where you have a bank account and serve a garnishment notice on that employer or on the bank. And then the employer and or the bank has to notify you that they received this notice from a debt collector or from the creditor, and say, is this accurate? Is this something that we have to follow? And you have an opportunity for you to object or to go back to the court again and say that this is not right. Sometimes the money in your bank account is exempt. There's many categories of that. They can't. Maybe we need to do probably another lunch and learn on just on garnishment, but it gets a little bit complicated. But there is a process, and you can object during that process, and that's something that an attorney could also help with, or our office, legal services, and give you some advice on if that's the situation that you find yourself in. So, some other examples of false or misleading representations that a debt collector might make are here on the slide. If you make it known to the debt collector that you dispute the debt in a letter, like sort of along the lines we were discussing earlier, say that that's a disputed debt, they need to then make a note in their file that you are disputing the amount. And that should be reported on your credit report as well. So that we talked about maybe doing another lunch and learn on what's called the Fair Credit Reporting Act. The slide refers to the FCRA. That is where the debt collectors and other creditors would report that you owe money. But if something is disputed, that should be noted. And especially when they continue to contact you over something that you dispute, that could be a violation of both the Fair Debt Collection Practices Act and the Fair Credit Reporting Act, depending on how it appears on your credit report. But basically, any kind of false representation or deception used to collect debt would be considered a violation. They are also required to include certain information in the first that a debt collector has with a consumer. They have to put specific information or follow up with that information if requested. So that could be a violation. And there's more. I have some hints later on in this presentation about more detail on what kind of information they're required to provide and how you can request that. And then sometimes they'll use a business or a company name that is not the true name of their business when they're collecting debt. And I think they're going to do that to make it harder for people to take them to court if there's a violation. They hide their true identity, and that would be a violation as well. And then there's a whole category called unfair practices, which is a lot of this overlaps with some of the other categories, but just to make sure that people understand their rights, they include this category of unfair practices, which again includes trying to collect any amounts that are allowed under the agreement, the credit card agreement or a lease, whatever the original debt that was for. If they see that they're trying to charge additional amounts that aren't permitted, that would be a violation of the Fair Debt Collection Practices Act. Threatening to take any, what the slide says, non-judicial action, which is outside of the court process, and trying to, repossess property or threatening to do things outside of the court process would be a violation of the Fair Debt Collection Practices Act. They can't just go to your employer or to your bank and tell them to start garnishing your paycheck without having a court order, like we talked about that process before. If they try to go around the court process, that's where they run into a violation. Even this one was an interesting example, communicating with the consumer by postcard, because the idea is, the only reason they're doing that is to embarrass you by putting that on a postcard. People can see that you're not paying your debts and whatnot. That would be considered a violation. If you do get a postcard, that's a great example, just something to hold on to as proof that they violated it, so that you can use that if you have to take them to court. Again, I mentioned this earlier, but this is worth repeating, is that if you tell the debt collector that you are disputing the debt in writing, and the 30-day period that in the slide refers to, you have to do that within the first 30 days of getting an initial contact from the debt collector. You tell them that you dispute the debt collector shall cease collection of the debt or the disputed portion and go back to that original creditor to get verification and mail that verification to you. So back maybe to my example with Mary and Kurt, if I say to Mary, I don't know what you're talking about. I don't owe Kurt any money, or not as much as he said he told you. Mary has to go back to Kurt and ask for a proof if I have a contract with Kurt or what it is, saying this is the amount that he owes me, and here's how I would prove it. Mary will then have to provide a copy of that to me before she can continue to try to collect that debt. And it's also important to note, even if you miss that 30-day deadline, you should still send a dispute if you can. But if you don't dispute for some reason, people get busy, or you don't realize that you could dispute that debt, it doesn't mean that you're admitting that you owe it. They can't because you didn't dispute it in 30 days. They might try to say that, well, you didn't send us a dispute, so now you have to pay it, and that would be a misrepresentation. So it's not the end of the world if you miss that deadline. So what to do if being harassed by a debt collector? And this is probably the most informative slide in the bunch. And I know, Kurt, you were talking about maybe having some of these links or posting these up along with this presentation. I'll let you explain that in more detail, but basically, if you're being harassed by a debt collector, one of the things you can do is reach out to an attorney. You can contact our office, the legal services, or I also have another website here, consumeradvocates.org. It's the third bullet point down. It's an organization of lawyers that specialize in this area, and highly reputable organization. And you can reach out to, and they have a list of different, it's not, Consumer Advocates is not a law firm of itself, it's an organization of lawyers, so they have a list that you can reach out to on that list that just happens to specialize in this. Or you can also write a letter on your own. That would be the sample letters link that you see on your screen. It's part of the Consumer Financial Protection Bureau, which is a federal agency that I know Kurt has talked about before. They do have sample letters on their website, and for all different kinds of things. If you're trying to dispute the debt, if you're trying to ask them not to contact you, different letters for different things, or a combination of different things on their website. And I did want to note that if you are thinking about taking a debt collector to court for a violation of the protections here, you can get some damages for the violations. You can get your attorney's fees paid for by the debt collector, so you don't usually have to put any money, pay the attorney up front. If you have a Fair Debt Collection Practices violation, the attorney most likely will represent you based on but you do have to do something within 1 year. That SOL is the statute of limitations, meaning if you don't do it within 1 year of the violation, then you lose the opportunity. So something to keep in mind.
And as John had mentioned, the links that are in this presentation, I'm going to be putting in the chat box here as we have this recording live. And if you're watching this in a recorded version on YouTube, just check the comments and the links will be listed in the comments.
Okay, and I have, did you get them, were you able to get them all, Kurt? I can only see my slides, so I don't see what's going out to the world yet. Okay, good. So then my next slide, I just wanted to touch on this earlier, and I know Kurt has mentioned this before, and for example, the lunch and learn on checking your credit score and checking your credit report. But there's another law called the Fair Credit Reporting Act that talks about what the credit reporting agencies and the debt collectors and the creditors have to do in order to make sure that your credit report is accurate. And if you do see that there are mistakes, and because sometimes there can be mistakes or identity can be confused. Sometimes people have other people's information on their credit report if their name is similar. So the Fair Credit Reporting Act provides a way to correct your credit score and credit report. And if the credit reporting agency doesn't follow the Fair Credit Reporting Act, it also provides damages and court costs and attorney's fees if you want to pursue legal action. And it has a little bit different statute of limitations, 2 years from discovery of the information on credit report, or 5 years from when the event occurred, which would be when it went on the credit report. But those are things that if you have questions about that, contact again an attorney that specializes in this, and on that website, the link that was provided earlier, or reach out to the legal services office and we can get you some more information about that. And again, some more links, resources that you can learn more about these things. One is, a couple of these are from the FTC, the Fair Trade Commission, Federal Trade Commission website. One about identity theft I always put on there because that's sometimes a problem that people see. We talked about this one before, annualcreditreport.com. That's where you go to get your free credit report. Consumer Financial Protection Bureau, mentioned that. The Minnesota Attorney General is also a good resource for consumers. And lawhealthmn.org. That's another one where you can get all kinds of helpful tips and pointers on different types of legal issues. Consumeradvocates.org I mentioned earlier. And then the last one is Southern Minnesota Regional Legal Services, which is where I work. And we provide free legal assistance to people if you qualify. And that's our intake number you can call if you think you might have a legal issue that we can help with. So that is pretty much it. I don't know, Kurt, if you had any other questions at this point. Otherwise, I appreciate you giving me the opportunity to talk about the Fair Debt Collection Practices Act, and I hope everybody learned something new.
Oh, John, it's been such a pleasure to have you on. And for those of us watching this, this is pre-recorded. So if you have questions, please do chat them in. And if I'm not able to answer them when we're showing this on Friday, I will pass those questions on to John and I can follow up with you with the answer. But if you do have questions after the fact, when you're watching this version recorded, reach out to either one of us and we're happy to get back to you. Another thing I like to always add when I talk about collections is your best bet that can really help a lot is as soon as you are aware that you've got a debt that is going to be an issue with paying it, reach out to that creditor and just explain the situation. Say, hey, this is what's going on. I'm having a hard time making my payments. What options are available? A lot of times, places have programs available to help you out if you're going through hard times, but they can't help you if they don't know that there's an issue. The longer that you wait, the harder it is for them to help you, and eventually that might go into collections, and then you're going to need to be concerned about these types of situations. So just reach out, ask for help right away. I know sometimes it's hard to do, but it's really worth doing, and that's helpful. All right, anything else to add, John?
Nope, I think that about covered it, as best we could, and I will look forward to hearing from you. If there's any questions, I'll do my best to answer or point people in the right direction.
All right, thank you everybody for joining us today. We really appreciate it, and stay tuned for future lunch learns.
All right. Thank you again, everybody, for joining us. That was some fantastic information. I'm just going to check the chat box here quick and see if we have any questions from our attendees. I'm not seeing any, but again, if you do think of anything, please reach out to us and we're happy to help. Be sure to like and share our videos and reach out to us if you have ideas for additional topics. We'd be happy to cover those. Thank you very much for joining us today, and we'll see you again next Friday. Take care. Bye.